HOA Beat. I'm Cindy with Key Community Management. Today we have a special guest with us, Ben Carr from the Law Office of Moretz and Skufca. Thank you for joining us, Ben.
Thanks for having me.
So we wanted to talk about an important topic today that seems to come up, but yet it's not anything that's addressed in our governing documents for our associations today. So it's the topic of social media. And often we find that residents in our communities have created a Facebook page, and people think that it is an official tool for communication within the community. So it's a real problem, and also it could be that a board member might have an idea to create the page on behalf of the association, that the board would populate the content as well. So I guess the question is, it seems like a great idea because there's no cost to the association for creating a Facebook page. Seems like a great way to communicate. Good on the budget, no funds are required. But there have been some concerns, and so we wanted to ask you today about, do you recommend this, and what can we do about it if it does happen?
Sure, and this is a topic that we see every day with increasing frequency. I believe there's probably new social media forums being formed right now that we may not even know about. But we definitely see a lot of communities and board members and individual members creating Facebook pages. Nextdoor.com I know is a popular site. Definitely board members are commenting on some of these sites, and that can lead to legal questions. So the underlying law for any of these issues basically comes down to what authority board members have. The general rule, and I'm going to talk about directors who of course are elected amongst the members, right, and also officers that are appointed by the board who are usually board members. I'm going to refer to them generally as board members, even though technically a director is different than an officer. And there's essentially two kinds of liability that we're primarily concerned with. Both of which derive from what authority those people have. There's, first of all, actual authority. That is the authority which is presumed from law when a board member or the president, usually, is signing a contract on behalf of the HOA or speaking on behalf of the HOA. Legally, we presume that person has authority to act for the association or to speak for the association. And that actual authority literally comes from our governing documents. Usually the bylaws will say the president can sign contracts, and that's actual authority. There's also what's known as implied authority. That's where we as an HOA are holding someone out as having a particular authority to speak or act on behalf of the HOA. An example would be if we have the vice president, say, signing all of our contracts. We are holding out that vice president as having authority to bind the HOA. And by extension, it can also be a board member who is holding himself or herself out as having that type of authority. Let's say we have a person who's on the board who's going out on Facebook and implying that the board is taking divisive views or saying racist things or hateful speech. And the impression is given that person has authority to speak for the board. That's a problem. What we look to from a legal standpoint is we say, would a reasonable person look at that board member who's speaking, and would they believe that person has authority to speak on the board's behalf? And if the board doesn't do anything about it or allows it to happen, then it's conceivable that whatever said by that person, whatever derogatory comments or divisive language, could be imputed to the HOA, potentially creating liability for the HOA as a legal entity. So one thing that also goes hand in hand with this is that we want to encourage people to sit on boards. Although a lot of members don't believe this, board members are volunteers. They're unpaid volunteers.
That's right.
And it is not a very fun job, and it is time consuming, but to encourage people to sit on boards, we actually offer them by statute in both the Planned Community Act, which references indemnity, and specifically in the Nonprofit Corporation Act, we actually indemnify our board members who are acting within the scope of their authority to make decisions for the association. For example, if a board makes a decision after considering all the facts available and it turns out to be the wrong decision, we don't want to hold that board responsible. We don't want to open them up to lawsuits, at least from a personal standpoint. We don't want someone suing them individually for acts taken in the scope of their duties as a board member. When a board member speaks out of turn without authority, that board member can open him or herself up to being sued personally for acting outside the scope of authority, in which case the association may not have the right or the obligation to pay the cost, to indemnify that person if that person gets sued. So that's something that board members should be aware of, and I think will hopefully keep board members in line if they actually think about what they're saying.
Absolutely. Well, it's a big deal. It's important for them to take it seriously. So what can we do to help limit the liability to the association? Is there some training? Is there some documentation that's available?
Sure, and that's something that we see every day, and I'm a firm believer that having an educated board resolves a lot of these problems.
Yep.
It is good to periodically teach your board what is appropriate and what is not appropriate. I think a lot of long-standing board veterans and especially new board members would benefit periodically from having a refresher course or even a board training 101 type of course. I know our firm offers training once a year to the HOAs that we represent, and we're happy to do that. We do like to get out of the office from time to time and meet our boards. Of course, with social media today, that happens far too infrequently. We rely on the telephone or emails more than we need to.
Yes.
But I think training is the first thing. Boards really should look to their property managers first for best practices and really what the guidelines are. And if a legal question comes up, they should look to their legal counsel. And that's the first way to protect against this type of liability. The second way is to have in place good policies to dictate how your board is supposed to respond to requests from someone, say on Facebook, or what exactly they are authorized to say. A lot of boards have adopted ethics policies, and this is something that is either addressed in that policy, or you could adopt a separate policy dealing strictly with social media. And that's something that if you adopt it, you need to comply with it. You can't just have a policy and not abide by it. But those are things that can be addressed in policies that your board should really have in place. And a third thing that some communities may find this helpful, I'm not saying everyone, but some boards will appoint a spokesperson. And the spokesperson really is the person who can speak on behalf of the board. And that probably has a number of benefits, but one of them is if someone sees a rogue board member out on Facebook saying things that are highly insensitive, then the members at least hopefully know that that person is not the spokesperson and is not speaking with the board's voice. They're speaking on their own, and therefore that the members would hopefully give that person less credence and wouldn't rely on it as much.
Right. And so maybe with the policy there would be a repercussion if that board member isn't following the policy.
Sure, that's something you do see in policies. One thing that you can do is somewhat censor a board member. I don't know how much effect it has, but just sort of to publicly silence that person or to admonish that person in a public way to at least let it be known that no, this type of conduct will not be tolerated. Of course, it's possible to have a board member removed, but that's not as easy a process as one might think. And that's kind of the extreme. But sure, your policies can address that and impose discipline for a board member who doesn't comply.
Right. I mean, if that's needed, that step should be taken. So, what we find is that people think that these Facebook pages are official communication on behalf of the association, and that the board is creating them. Is there a way that, as we said, we can't necessarily prohibit someone from creating a page and just a member, but can we make it so there's a message on the site that would say, hey, this is not official?
Yeah, well, from a legal standpoint, it is very hard to silence people. And we typically don't want to silence people. We want to encourage people to speak freely, and sure, we understand that our leaders, all the way from the president all the way down to our board, they face criticism, and we don't want to discourage people from criticizing our leaders. So it's very difficult just to tell someone, no, you can't create a Facebook page. But as a first step, if someone does go out and create a page that potentially misleads homeowners, I think a request should be made that somewhere on that page it is disclosed that that is not the voice of the board, that it's really an unofficial page, and that those opinions expressed on there are not the board's. If that doesn't work, let's say the page creator doesn't respond, or they just refuse to notify members, then the board should probably issue a firm statement stating this is an unofficial page. Members, please disregard it. If you see a comment on there, it is not from the board. And that can maybe be effective to members. There's not a great legal way to handle that, unfortunately, but those are two things that could certainly be attempted.
That's good. So, we were talking earlier in our office about the ways that we do communicate with our associations, in working with our board members. So what we do is, a lot of our communities have a website which has the capability for e-blast messages to be sent out, and it's a great tool because people sign up for it and they know it's an official communication. There's also a place on the site for announcements, so things are posted there. And then, of course, you can always send a newsletter or a letter out with information. And some people have a message board at the entrance of a neighborhood. They choose to put that in their budget, where when people drive in and out, they see certain messages. So we find that there are ways to do it so that people are aware that it's an official communication tool, and they don't have to wonder. So it's an interesting topic, because we find this isn't covered in the covenants. It's not covered in the bylaws. So it's new. With technology, things are always changing. So what happens is it forces us to change and to address things as they come up. So we want to encourage everyone to, if you have an issue with this, contact your management company, contact your law office that you work with, work through it. There's ways to address anything, but you just might not already have a plan in place, but you can work one out.
Sure, and to your point, I think one of the best ways to combat these rogue Facebook pages or rogue board members is really to have open meetings. That is one thing that boards, I think, are becoming more sensitive of, that a lot of these problems really arise because people have this negative perception that boards are operating out of a smoky room somewhere and over a bottle of scotch or something. Right. But no, that the board is out there trying to get people, or basically that they're profiting somehow from sitting on the board, when in reality they're not. And by having open meetings, you can encourage members to attend, and I think that certainly cuts down on this kind of chatter, because people see that the board is not acting nefariously. They don't have a negative intent. And people see that the board, really, most of their job is as boring as it gets. It's signing checks or deciding these very basic issues. And once they see that in practice, a lot of these issues go away. So that's one major tip that I think boards are becoming aware of, and I think it really cuts down on these kind of negative social media posts.
I think it's a great point, because what happens is people post information based on a lack of knowledge. And when you don't have the truth to work with, you're just guessing. And so these open meetings and more communication in print from the board lets them know, hey, here's what we're up to. Here's what we're doing on your behalf. Here's how we're spending your money. So I think it's a great suggestion. So thank you, Ben, for being with us today. And I hope we're all learning something new. Thank you for joining us today for the HOA Beat.
Thank you.